So my name is Zachary Florent. I'm the Outreach and Education Coordinator for the U.S. Equal Employment Opportunity Commission Seattle Field Office. The Seattle office, you may wonder why Seattle is participating in a California webinar. Seattle office is part of our San Francisco district. EEOC, if you're unfamiliar, we're the federal agency that enforces the nation's anti-discrimination laws for the workplace. So in other words, under the laws that we enforce, it's illegal to discriminate against an applicant or an employee because of their race, color, religion, sex, and that includes pregnancy, pregnancy-related conditions, gender identity, sexual orientation, national origin, age, 40 and older, disability, or genetic information. EEOC.gov is where you can find more information about what we do, but broadly speaking, our mission as an agency is to prevent and remedy unlawful employment discrimination and advance equal opportunity for all in the workplace. I'm going to hand it over to Sharon to introduce herself.
Thank you, Zach. I'm Sharon Turman. I direct the Work and Family Program at Legal Aid at Work. We are a nonprofit legal organization based in California that seeks to advance the workplace rights and well-being of families with low incomes. We engage in education and outreach. We represent folks whose rights have been violated. We offer free, confidential legal advice through clinics and helplines, and we advocate for policy and systems change. We have expertise in several areas addressing workplace issues, including work and family related issues and disability rights, which are relevant to our presentation today. And I will turn it back to Linda.
Hi, everyone. I'm Zach's counterpart in San Francisco, and I'll be stepping in for Rashida for the moment. Let's see. We wanted to start with a strong statement that stable employment is a social determinant of health. We're very excited to have you all join us. Our hope is to share with you some insight from the patient's perspective in this matter, switch over to thinking about what are the considerations that an employer looks at in order to best frame up what you as the medical provider might need to consider. We'll conclude our session by looking at what makes a good note versus a bad note, and we're hoping you'll pick up good skills with this. Last thoughts on this. Again, we're very excited to bring this topic to you because we've long realized there's a triangle here. We often focus on our workers, your patients, and employers, and missing maybe in this formulation is what is the role of the healthcare provider? This is our first foray into it. So whatever insights you get into this, if you want to supply your perspective, we definitely welcome your input, and we'll share our contact information at the end so that we can discuss that. Okay. Next, we're going to take a pop quiz, a poll of our audience participants. We ask that you respond to us honestly with your thoughts on this poll. To you, as the healthcare provider, writing doctor's notes represents A, the least fun part of my job, B, a time suck when I have zero time to spare, or C, it's a necessary evil that could have a big impact on my patient's health. Or D, a task I feel well-trained and resourced to handle. If we could open up the poll and allow people to go ahead and respond. I see some people responding in the chat, or if we can pull up the poll and offer that to people. Hopefully that's showing up on your screen as well. You can choose the choices on the poll, and we'll give people just a few more seconds to respond in the chat. I'm seeing a lot of D. I'm seeing some C. And can we share the final results on that poll? All right, we're seeing a majority of people saying this is a necessary evil that could have a big impact on my patients' outcomes, and we see a kind of a variety. I'm hoping that this slide gives you a sense. We understand that this might not be a fun thing, but it could have a big impact on folks. So thank you for participating in that poll. Let's move on to our next slide. Again, part of the reason we were motivated to offer this free webinar is based on some of the conversations we've had out there. And here you'll see a news report on a survey of a national survey of physicians, which indicated, again, given this poll was about a slightly different topic, it showed a lot of doctors maybe are not as familiar with what the ADA requires of them in various roles, that many don't maybe fully understand the concepts behind reasonable accommodations, and that there might be some fear and misgiving out there on this topic. So next slide is, so what might be going through the mind of the patient, right? Here are some thoughts that may be floating through your patient's head. They're concerned about being able to continue working, balancing the need to, maintain a livelihood, maintain health coverage while looking out for their health. What if they need more leave? How do they hold on to their job? So with regard to the patient, it might be helpful to think of your role as helping your patient obtain workplace accommodations and be able to hold on to their job. So some good things to do would be address the limitation, right? That is indicated by the condition that your patient has. Think about how that impacts their work, but don't disclose the diagnosis or share every detail of the disability. Next slide. As we think about this, it may be helpful to reflect on the way we think about disability. In your work, you're probably accustomed to framing it up in a particular way, but let's acknowledge that there's a multitude of contexts, there's a multitude of laws out there. And so let's just think about these three models of disability as we approach our topic today, right? As a healthcare provider, you're probably used to addressing and trying to fix the medical condition, right? This person might not be able to see or hear, they can't walk, and maybe therefore, as a result of condition, they're perceived as not being able to work, or they actually cannot work, right? So again, there's a perception that this person needs help and might be dependent. Our focus is on how can we fix or cure this person's medical condition or fix or cure this individual, right? However, the community has also framed up another model for looking at disability where, right, in maybe conflating the medical condition with the person or the patient, then they become perceived as part of the problem to be fixed. Whereas the social model proposes that, maybe the barriers are really in how society has construed itself or sets itself out, right? There's no ramps, no elevators, there's no translation, it's in the design, right? This results in the patient or worker being isolated and having poor working conditions or prospects. So the goal in the social model is how do we fix society? I would say that all of your hosts come at this issue from a civil rights perspective where we're looking at solving the problem of discrimination, right? Where there's a lot of myths, fears, and stereotypes out there around what it means to have a disability. Like this, again, the worker is perceived as a person who cannot do something, or maybe even is perceived as somebody who's asking to bend the rules. I think our goal is something that hopefully addresses both the individual and society for the result of inclusion, self-determination, and equity. Next slide. All right, so what could be going through the employer's mind, right? You'll see a range of responses out there, employers who do wanna honestly get their worker back to work. I've heard from some doctors, you sometimes get these employers who are very maybe skeptical or dubious or kind of wondering what's going on here. So you may encounter a range of attitudes and opinions out there. Maybe it's helpful to frame up your role as how can you help the employer to accurately understand the patient's limitations, right? So here are some good do's to do. Get your patient's input, be specific, be clear about the start and end date. Try to avoid using unnecessarily restrictive language or overly broad timelines, because that's going to scare your employer. And with that, next slide. I'm going to turn it over to Zach.
All right, so what are the rules? What are the relevant laws here? And maybe even more importantly, why do we think this is important for you to know? We're going to begin this part of the conversation by making two assumptions. The first is that you, in your capacity as a medical professional, probably don't want your patients to come to harm. Fair? The second is that the vast majority of employers also don't want their employees to come to harm. So moral justifications aside, both medical professionals and employers understand that there are also legal consequences for not fulfilling your obligations to protect someone in your charge from harm. So the relevant laws that we're going to be discussing today are the federal law, the Americans with Disabilities Act, which is enforced by EEOC, and then also California state law, the Fair Employment and Housing Act, which is enforced by the Civil Rights Department, and also the California Pregnancy Disability Leave Law, PDL, also enforced by Civil Rights Department. EEOC also enforces the Pregnancy Discrimination Act, which is an amendment to Title VII, which is our big civil rights law. So these laws are the guidelines that employers must follow to ensure their employees are afforded their legal rights in the workplace. And in order to be in compliance with these laws and to avoid things like staff turnover, investigations by us, costly and embarrassing litigation, morale issues, all that stuff, they develop policies and practices to ensure they're doing the right thing by their employees and also operating in a fair and legal manner. So in this next section, our goal is to help you understand what's on the employer's mind when they ask for your patient to come back with a doctor's note. Why are they doing that? What does it do? What are they looking for? Hopefully we can demystify the process a little bit, and so doing help make your role in this whole process a bit clearer. Next slide, please. So the ADA, Americans with Disabilities Act, and California's Fair Housing and Employment Act provide similar protections for employees and job applicants. We're going to talk about these protections provided by both, and where possible, I'm asking my friends from CRD to pop in and highlight where California law may go above and beyond what the federal law requires. But in essence, and this is baked into the ADA, the goal of this law is to assure equality of opportunity, full participation, independent living, and economic self-sufficiency for people with disabilities. So as with our anti-discrimination laws, both of these prohibit discrimination on the basis of disability, record of disability, perceived disability, and association with a person with a disability. So what that basically means is, under these statutes, it's illegal for an employer to take adverse action against somebody because of one of these characteristics or one of these reasons. Next slide, please. So the ADA and the FEHA both go a bit further than other anti-discrimination laws, requiring that employers provide reasonable accommodations, which we're going to go to in a lot more detail here in just a second. Employers used to do a lot of hand-wringing to get people to prove that they had a disability and so could enjoy coverage under the law. This wasted a lot of time and left many qualified people unable to work because, for whatever reason, it was decided they didn't meet the standard for disability. But that wasn't the point of the ADA. The ADA wasn't intended to create this extensive test for establishing disability. So Congress amended it to make it crystal clear that the emphasis should be on finding accommodations, not certifying whether or not someone has a disability. So this is a point that when we speak to employers, we really emphasize. So we're going to take a look now at how disability is defined. And I know there was a question that came in through the Q&A. Hopefully this will demystify that a little bit. Next slide, please. So it's worth acknowledging probably multiple times throughout this presentation that there are a lot of definitions related to disability out there beyond just the regular definition that people use in casual conversation. There's also a lot of different legal thresholds for what is or is not a disability. And things like Family Medical Leave Act, Workers' Comp, Social Security, they're going to all have their own definitions and their own nuances. For the purposes of this conversation and for the purposes of accommodating folks with disabilities, the main takeaway is that the standard is intentionally broad to favor maximum coverage. So under the ADA, there's 3 main prongs, and they're listed on the screen for you. But I don't want to overcomplicate things, so I'm going to briefly note that individuals who just have a record of a past disability or who are just regarded as being disabled aren't entitled to accommodation. So I'm going to focus instead on that first prong, especially since this is where you as a healthcare provider may be frequently called upon to help provide verification. So a disability is an impairment that substantially limits a major life activity or major bodily functions. What do those mean? Major life activities, this is a non-exhaustive list that can help sort of guide your thinking on the topic. Major life activities include things like caring for yourself, performing everyday manual tasks, things like seeing, hearing, eating, sleeping, walking, standing, reaching, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, et cetera, et cetera, et cetera. Non-exhaustive list. So beyond major life activities, major bodily functions, limitations to major bodily functions, such as functions of the immune system, sensory organs and skin, impairments to normal cell growth, digestion, bowel function, bladder function, neurological or brain function, respiration, circulation, cardiovascular function, et cetera, et cetera, et cetera. The point is that if an impairment limits major life activities or major bodily functions, we can easily consider that the person is disabled under the definition of the ADA. So we can move past worrying about that and get right into the next slide, which is reasonable accommodations. So what are reasonable accommodations actually? The graphic here shows 3 arrows. We can think about these arrows as employees. What is the job of an arrow? An arrow's only job is to go in the direction that it's pointing. What does a brick wall have to do with that? Absolutely nothing, but it is a barrier getting in the way of these perfectly qualified arrows, right? A reasonable accommodation is a change in the way things are done that allows qualified individuals with disabilities to perform the jobs that they were hired to do, okay? Reasonable accommodations aren't about treating every person in exactly the same manner. They're about providing equitable access to participate in the workplace. Reasonable accommodations are specific to the individual needs of the employee or applicant, and they consider very specific things like the essential functions of the position that they're in or that they're applying for. All right, next slide, please. So what's the process? How do I as an employee go about getting an accommodation? So once I identify that I have a need, right, the next step is to request the accommodation. Go to my employer and say, hi, I need an accommodation for such and such. That first step, that request, should trigger an informal, interactive process between the employee and the employer, wherein the ultimate goal is to find a reasonable accommodation that allows the individual to perform the essential functions of their job. And this is where your role comes in as medical providers, right? Employers are frequently going to ask for documentation or clarification from a healthcare provider to support that need for an accommodation. So let's talk about sort of what the employer has in mind at the next slide, please. So when an employer receives a request, the first hurdle is verifying that they have a disability according to the ADA. So remember here, the bar is incredibly low. All that's needed is verification that the condition substantially limits, or under California law, merely limits a major life activity or major bodily function, right? So they're asking questions to see if they have a disability, and then they move into the next spot. Once they clear that hurdle, which again should be relatively easy, they try to determine whether or not the accommodation in question is reasonable. They take into consideration the specific requirements of the job, the limitations of the individual, and the potential impact an accommodation might have on operations. So let's go to the next slide and talk about how exactly an employer determines whether or not a particular accommodation request is reasonable. there's two requirements, and you've heard me say them already. The first requirement is that the employee must be able to perform the essential functions of the job. The second requirement is that the accommodation must not cause an undue hardship to the employer. In other words, the accommodation must effectively allow the person to perform their job without significantly disrupting operations. Note too that there's no requirement that a person's preferred accommodation be provided. That doesn't mean it shouldn't be taken into consideration, but the requirement is only that it is effective, right? That it effectively accommodates the person. Let's break down these two prongs just a tad bit more. Next slide, please. So essential functions are the reason that the job exists, the reason that it was created. Essential may also take into account an individual's particular expertise or specialized skills, or potentially the number of available workers who can do a particular job. So for example, if my job is widget maker, it would not be reasonable to remove widget making from my list of duties. Rather, it would be reasonable to explore alternative ways for me to make widgets, maybe going outside what's conventionally done for widget making. It's worth noting that many jobs have side duties, non-essential functions, like a food server might be asked to help sweep floors before their shift or after their shift. Somebody in a call center might be asked to help carry packages from the mailroom. An attorney might be asked to help set up a virtual meeting. An employer would have a hard time arguing against an accommodation that limited or delimited types of duties that are not essential functions to the job, that aren't really related to why that job exists in the first place. Next slide, please. So next, the employer has to consider the impact or potential hardship for providing an accommodation that might have on the business. The examples here are some factors that they have to think about. So first and foremost, the nature and cost of the accommodation, and that in relation to the financial resources of the business. Now, most accommodations cost under $500, and most employers shouldn't have any trouble with that sort of expense. But there are cases where maybe a small business is facing whether or not an accommodation is going to really be too costly. That could be an explanation for undue hardship. Also taking into consideration the size of the business, like how many other employees might be available to cover a particular aspect of the job or provide assistance, the type of work performed. The impact on operations, is this going to significantly change the way the employer does business? And then lastly, the safety of the individual requesting the accommodation and the safety of other employees. Is an accommodation going to put that person at risk for further injury or harm? Next slide, please. So this is a non-exhaustive list of examples of accommodations that are commonly used, right? And in addition to verifying that your patient has a disability, your patient might be asking you to help explain to their employer how a requested accommodation might help or suggest other alternatives for accommodations. Remember, reasonable is a case-by-case basis. So there's not a circumstance where in every single case, every single item on this list is going to be reasonable. It's an individualized assessment, again, taking into consideration the specific person, their limitations, and the job that they're doing. But frequently, accommodations that are typically considered reasonable or that are typically workable are things like periodic breaks or a private area for rest or to take medication. Modifications to processes like the application process, the work environment, or how things are done. Making facilities accessible, modifying or obtaining special equipment, assigning marginal tasks to other folks like we talked about earlier, part-time or modified work schedules, maybe coming up with a delayed start time or delayed end time for a shift, modifying how supervision is done, for example, modifying the way communications happen for a particular person. And lastly, leave of absence for a reasonable period of time. Generally speaking, these all can be worked out. Generally speaking, these could be considered reasonable. Next slide, please. Now, again, generally speaking, these accommodations here are not considered reasonable. When I was an investigator in Chicago, these sorts of requests came up all too frequently in cases that I was looking into. So for you, understanding that these sorts of requests are generally going to be rejected by employers might help avoid unnecessary delays or other complications for your patients. So generally, again, it's not reasonable to eliminate essential job functions or lower productivity or quality standards. Provide new supervisor, excuse bad behavior, be tasked with monitoring medications for an employee. I'll note too that the guidelines for disability accommodation are different for workplace injuries. So, for example, light duty might be appropriate for someone who's recovering from a workplace injury. Generally, it's not reasonable as an accommodation for a disability. Also, indefinite leave of absence, it's hard for an employer to, plan its operations if it doesn't know when they can expect somebody to be back. So that's generally considered not reasonable. Again, as with the previous list, there may be exceptions here, but generally, these requests for these sorts of accommodations should be avoided when possible. All right, next slide, please. So what happens when the employer says it's not reasonable? Again, so we're presuming that the employer is acting in good faith here in accordance with their obligations under the law. A no to a particular request should not be the end of the discussion. A no should mean that we keep talking, or if needed, we go back to the drawing board until we can figure out something that does actually work. An employee might be returning to you because their employer asked for clarification about the restrictions or the accommodation that was suggested. But even with the best of intentions, this whole process can get frustrating and drawn out due to circumstances beyond anyone's control. And in the meantime, it's not uncommon for employees to be left in a sort of work limbo. I've seen people being put on sort of an unpaid leave status until the accommodation question is really hashed out and figured out all the way. If an accommodation can't be found, here's what are the potential next steps, right? So the first one there is what's known as the accommodation of last resort, right? So if we can't come up with an accommodation for this particular role, the next step isn't separation. The next step should be looking for another role that the person can go into. I don't want to go into it in too much detail, but if there's a vacant position that the employee is qualified for, an employer should be putting them in that position before taking them off the payroll, right? This might mean a decrease in pay. They're not required to promote somebody, but if there's another comparable, lateral, or lower position available, employers should be moving employees to those sorts of positions before removing them from the payroll. Additionally, as I mentioned before, if that's not possible, an employee could be placed on a sort of leave status, potentially without pay or benefits. And then lastly, if nothing else is working and we really can't come to it, there are circumstances where an employee can be separated from employment. That's a lot of information. I'm going to take now some time to go through some of the questions that came up, and I want to hand it over to Sharon now to talk about some of the pregnancy-specific considerations.
Thanks, Zach. So I'm going to switch gears right now and talk a little bit about accommodations related to pregnancy. And I'll first note that under both state and federal law, it is unlawful for an employer to discriminate against a worker based on pregnancy or childbirth or a related condition. But in California, we actually have our own pregnancy accommodation law that goes above and beyond what workers are entitled to under federal law. And this law applies to all employers with at least 5 employees. And it entitles pregnant workers to reasonable accommodations for their pregnancy condition or related condition. What's important to note is that in California, you actually do not have to be disabled. You do not need to meet that definition of disability that Zach spoke about earlier in order to be entitled to a pregnancy accommodation. This comes up quite a bit. I'm, in fact, advising a pregnant worker right now who asked for modest pregnancy-related accommodations. She provided a note from her provider, her healthcare provider, certifying the need for these accommodations. And the employer, which is an employer that's based out of state and has operations in many other states, and so may not have been super familiar with the California law, responded by giving her a form asking her doctor to fill out really specific questions under the ADA, under the disability law, and asking, does she have an impairment that limits a major life activity? that was an inappropriate request because it's not required under California's law. By nature, of course, pregnancy is time limited. And so the rules are a little bit different. All you really have to do is certify that your patient is pregnant, and it's your opinion that they should have an accommodation for their pregnancy. The examples, there's plenty of examples. Non-exhaustive list can include frequent bathroom breaks, breaks to have a snack, a place to sit, help with heavy lifting. And it's also really important to note that in California, under this law, you cannot force a pregnant person onto leave if they have not requested leave and if they're able to keep working with their accommodation. It's also, this is something we actually see quite a bit, that employers receive a request for an accommodation and then they put the person out on leave and say, we can't do that. And of course, that can have negative impacts on the person's ability to earn an income and prepare for welcoming a new child, and perhaps on their maternity leave later. Some tips for pregnancy-related accommodations include starting small, being really specific, and including things that the worker can do. Next slide. So we also in California have a special law called the Pregnancy Disability Leave Law that allows workers who are actually disabled by pregnancy or childbirth to take up to 4 months of job protected leave during their pregnancy-related disability. Again, it covers workers at employers with 5 or more employees. Health insurance must be continued during these leaves, and the leave can be used intermittently. It could be used for prenatal care. It could be used for severe morning sickness. This is a law that, while you are entitled to 4 months, most people with typical pregnancies and that are uncomplicated will only need leave beginning around 36 weeks of pregnancy through 6 or 8 weeks postpartum, depending on the type of delivery. Just important to note that a doctor's role may be twofold when it comes to pregnancy disability leave. On the one hand, they may need to certify to the employer the need for pregnancy-related disability leave. And then separately, there may be a certification to the Employment Development Department to certify the need for state disability insurance benefits. I will going back, I see a question in the chat. Does a pregnancy-related accommodation need to be reasonable? And the answer is yes, it does. So although there is no undue hardship exception under pregnancy accommodation law in California, it still needs to be reasonable. So some of the things that Zach mentioned earlier about generally unreasonable accommodations would still apply in the pregnancy context, but you also have to consider that, again, we're talking about time-limited accommodations. Many things like stools and breaks and things of that nature should be considered reasonable in most circumstances. Next slide, please. Okay, I think we're going back to Linda for this one.
Yes, sorry for the gap. So we've already talked now from the patient/workers perspective, and we've delved a little bit into the employer perspective. And I suspect we have a lot of employers because I see some great comments in the chat from employers with their questions and also their thoughts on what they're getting out of medical notes. So thank you for that. Let's focus in then on what might be going through your mind as a medical professional, right? And so in this case, there may be a number of factors going on. I know from some of the initial conversations we had as we were preparing for this training, there's this strong sense of time pressure, right? I don't have time for this. This is, I want to be treating my patients. There's so much pressure to get different things done, right? I also heard a sense out there that it might be safer to be broad and general in these notes, but hopefully you're getting a sense from some of the comments that there could be some issues involved in being overly broad and overly general, or alternately in sharing too much information. So we're going to delve into that a little bit more. There might be a sense of what's my role in this, right? Is this just a matter between the employer and the employee? We're going to hopefully try to answer some of those questions for you, right? So again, here we're saying, let's support your patient's personal and professional well-being, right? Social determinant of health, employment. Let's listen and collaborate with the patient, and let's try to write an accurate, specific, and effective letter, right? Okay, perfect. Next slide. Turning it back to Sharon.
Thanks, Linda. So yeah, why are you being asked to write these accommodation notes, and why is your role so important? For one, when a note is effectively written, it can help your patients receive the adjustments they need to stay healthy and safe, and to keep earning an income and receiving their health insurance and protecting their job. On the flip side, when a note is poorly written, it can lead patients to be forced on leave, to even lose their jobs in some circumstances. And of course, that can have negative impacts on their health and well-being, and not to mention their economic security. Talking about workplace issues with your patients can actually save their jobs. Reasonable accommodations should be requested early, as soon as there is a need, not before there's a need, but as soon as there is a need, ideally before the patient's performance begins to suffer. As Zach noted earlier, it's not a reasonable accommodation to excuse poor performance. And so if the employer is not aware of the need for an accommodation and the employee's performance declines, then they learn of the need for the accommodation later, they don't have to go back and take that discipline away from before they knew of the need. And so if an employee can get the accommodation they need to be able to effectively perform their job, they can avoid discipline and other negative impacts at work. Next slide, please. Okay, so one common question we typically get is what information should be included in your note? And I'm going to focus for now on California law, but I think the concepts are similar under both federal and state law. California does have stronger privacy protections, and so in California in particular, you do not need to disclose the specific disability, as we've alluded to. You do need to give enough information so the employer knows the patient does have a disability within the meaning of the Americans with Disabilities Act or state law. Also describing the major life activities or bodily systems that are limited by the disability and that may be affecting the job. And then you can also include the patient's need for accommodations for those limitations, although you don't necessarily need to describe the specific accommodation. Next slide. Okay, some things that the employer is not entitled to when it comes to medical documentation are access to the patient's entire medical file. This sometimes happens in these forms that the patient gives to the healthcare provider, and it asks for the entire medical file. That is something that an employee is not required to give, and they should not be punished for refusing to give. You also, as we've said, don't have to give the specific diagnosis. And it's important to note, of course, that doing so could be harmful because of stigma related to certain diagnoses. And so just to give an example, if your patient has irritable bowel syndrome, it would be enough to say that my patient has a disability that limits or substantially limits her gastrointestinal system, and due to that condition, they may need to work in an area that is close to the restroom. There's likely no need to discuss specific symptoms like incontinence or things like that. I will say there are some COVID-related exceptions here to the rule about not disclosing certain medical facts. Of course, given COVID, employers are entitled to know things like COVID symptoms and test results and vaccination status. And next slide, please. So it is fairly common for employers to have forms that they want their their employees, healthcare providers to fill out. So what do you do if you're asked to fill out these forms instead of writing a note? I will say, practically speaking, it will streamline the process for your patient to fill out the form. But you should also keep in mind that the guidelines we've talked about should apply. So if the form happens to ask you for more information than they're entitled to, don't fill out that part of the form. Just follow the guidelines about what the employer is entitled to. Be careful about documenting the patient's inability to perform essential functions of their job, and you might consider saying that your patient can perform the essential functions of their job with an accommodation. Next slide. Okay. Yeah, so a couple other tips on these forms. It's a good idea to talk to your patient about what their limitations are, and in light of those limitations, whether they think there may be other ways for them to perform their job tasks. And that can lead to a helpful conversation about reasonable accommodations. It also might be helpful for you to provide more specific information that clarifies the relevant details of the patient's limitations and possible accommodations. Next slide, please. So what if you want to suggest an accommodation, but you're not sure what to suggest? Well, your patient might have ideas. I will say again that the employer doesn't have to provide the specific accommodation requested by the patient, as long as they provide something that is effective. But it might be helpful for the patient to go into the conversation with their employer having an idea about how they think that they could address the issue. The other thing, which I see has already been put in the chat, thank you, is the Job Accommodation Network, which is an amazing resource that you can consult. It has a wealth of information about various reasonable accommodation options for a variety of disabilities. So that's another place that we highly recommend consulting. And with that, I'll turn it back to Linda.
Great, thanks so much, Sharon. So I know we've been kind of going through this rather rapidly, but we thought it would be helpful to substantiate what we're talking about with some examples. So we're doing our case studies. Case study 1 involves mental health, right? So in this scenario, what we've got is Lisa is an administrative worker, works remotely for a small literary magazine, right? And last year she began struggling with anxiety. It was manageable at first, but she found herself withdrawing from social events, activities that used to bring her joy. Soon she's having panic attacks every day. She's avoiding leaving the house. So her partner encouraged her to seek professional help. And she enrolled in an intensive outpatient psychotherapy program, right? She can't afford to miss work, but thankfully her job's 100% remote with a flexible schedule. She requests reasonable accommodation from her employer, which was simply this. She wants to block off 2 hours each day to attend therapy. In return, she offered to work late every day to make up those hours, right? So she gets a medical note from her doctor, which the employer did not respond to very well. And in fact, the employer places her on unpaid medical leave. It takes her a week to get a new note. And in the meantime, she's having the worst panic attacks of her life, right? So let's see, with this, what happened was she was placed on unpaid medical leave. Several days she was spending calling and emailing the doctor and human resources. And again, that in addition to the worst panic attack of her life, for a week, she's unable to work until she gets that doctor's note. So again, she just wanted to be able to block off those 2 hours to attend therapy, and she agreed to make them up. Remember, she has a flexible schedule. So that is what she had. Again, here in our case study, you will see the letter that her doctor sent her, right? I am Lisa, last name's treating physician. Due to a severe anxiety and panic disorder, this last name is incapacitated for the foreseeable future and cannot perform the duties of her job while she obtains treatment. That's the letter she was given. And what we're going to ask you is, what could the doctor have done to improve this letter? What would you choose to write a better letter for our patient here, Lisa, right? So could you try to more accurately describe the suggested reasonable accommodation? A. B. Include a start date and a projected end date. C. Include more information about her diagnosis. D. Specify that Lisa can perform the duties of her job with an accommodation. E. Answer all of the above. Or F. It's A, B, and D. So feel free to answer the poll. Hopefully you can all see the poll on your screen. If you're not getting that for some reason, you can vote in the chat. Let us know what you think about this. I'm going to give you a few seconds to vote. I see some votes in the chat. I'm going to give people just a few more seconds to vote on the poll and maybe ask our wonderful poll administrator to share the final results. All right, I'm very happy to report that a lot of people reported A, B, and D. We know that sharing the diagnosis, especially under California law, is not a good idea. So we go with letter F as well. All right, I'm gonna turn this next case over, or we're gonna, next slide, please. Thank you for participating. I see employers agreeing F is the way to go. Great, good to have that weigh in. Here's our second case study. In this case, we're considering pregnancy, all right? So Lena works as a cashier at a grocery store, 31 weeks pregnant. The pain in the back of her legs and in her back when standing. She wants to keep on working until she reaches 36 weeks, but she probably needs more frequent breaks and the ability or the ability to sit, right? And maybe some help with bagging heavy items. So that's our scenario. Let's move on to the poll. Help us determine which is the more effective letter. I'll read it to you in case you're not seeing the screen or if it's too small. Here's option 1. We have option 1 and 2. First, I am the treating physician for Lena. Due to her pregnancy, she needs a 10-minute break every 2 hours and or to sit during her shift. She should avoid lifting over 35 pounds. Second letter, I am the treating physician for Lena. She is unable to perform her regular job duties due to her pregnancy and should be given light duty until she begins her maternity leave. I'm going to let you guys vote first, and then I will turn it to Sharon to discuss. So what do you think? Letter 1 or letter 2? You can vote in the poll, or if for some reason that's barred for you, tell us what you think in the webinar chat. I'm just going to give folks a few more minutes to vote. And I will ask the administrator, I'm seeing some different answers. Can you give us what folks have voted on? What are the results here? All right, overwhelmingly, I see people voting for option 1. Sharon, what do you think about this?
Yeah, I mean, so I'm glad to see that because option 1 is the more effective note, and the reason is that it's much more specific about the accommodations that Lena needs. Option 2 is problematic, of course, because it focuses on her inability to perform her job. It says she cannot perform her job due to her pregnancy, and it also uses the term light duty, which is very broad and hard to understand. And so it may be seen as unreasonable. And so an employer might get this note and place Lena right on unpaid leave for the rest of her pregnancy, which is not the outcome that she or her healthcare provider were hoping for. So option 1 is definitely the better note.
Thank you so much for that. Folks, I'm you because I got a message that my internet connection apologized if I glitch on you.
Linda, I'm going to take over on this
I'm going to
last
look
one.
at an instance of, so yes.
Lynn, I'm gonna hop in because you're glitching out a little bit. The third case study, your patient Lynn is undergoing chemotherapy. She reports that treatments sometimes leave her feeling too ill to be able to do much of anything, but typically these symptoms only last for about a day or so after receiving treatment. Lynn confides that she is running low on sick leave and vacation time, and she can't afford to miss too much more work. She told you that everyone on her team has worked remotely for most of the past 2 years. This is one that is based off of an investigation that I did in Chicago. Can go ahead and share the poll. The first question, or first option rather, which is more effective? Option 1, Lynn has a condition which qualifies as a disability under the ADA. She requires telework as a reasonable accommodation for the foreseeable future. Option 2, Lynn has a medical condition and is receiving treatment on a weekly basis for an initial period of 6 weeks. Treatment will weaken her immune system and cause temporary weakness and fatigue lasting for up to 24 hours. Which one of these is most effective? Option 1 or option 2? All right, poll should be live. Give folks a couple of moments to answer. All right, let's go ahead and see those results and share them with folks. Ooh, got a little bit of a split here. Most folks went with option 2, and I would say of these two, that's the one that I would probably go with as well. The problem with number 1 is it really doesn't provide a lot of wiggle room, right? Not only does it not really describe, any sort of limitations, if telework really isn't a possibility for that position, this is just going to require Lynn to come back again to her healthcare provider and get clarification, get a different note. So this could make the process last a lot longer. Of these two, number 2 is better, right? It makes it easier to establish that she has a disability and for the employer to consider a variety of possible accommodations, right? Now, perhaps the best option isn't listed here. Maybe a third option would be a bit of a hybrid of both, right? Talking about, what the limitations are, but then maybe also going a little bit beyond that and suggesting that telework possibly could work as a good accommodation. All right, I'm going to hand it back to, I think, Linda. Is Linda's?
Okay, I hope, how am I glitching or am I okay? All right.
I can hear you.
Thanks for stepping in, Zach. All right, so that takes us through our organized materials. We just wanted to share some resources with you. So if we could go to the next slide. If you're a medical provider that has specific questions about leaves of absence or reasonable accommodations, Sharon, who should we turn to?
Yeah, so you're welcome to contact Legal Aid at Work. We have actually, we have a healthcare provider toolkit, which is shown here and actually includes a number of template letters with all the right buzzwords to use for your patients for various kinds of accommodation requests. And we also have 2 helplines, and we are available to provide free guidance to patients and can provide technical assistance to providers as well. So the Disability Rights Helpline for issues related to disability accommodations, and other forms of disability discrimination, and then our work and family helpline, which focuses on pregnancy and parenting and caregiving related issues.
Great, thank you so much, Sharon. And next slide, please. So we wanted to provide one main resource for healthcare providers, but here are some additional resources. Again, these may be resources that are useful to you as a healthcare provider, or they may be resources that you refer your patients or the employers you're interacting with to. So here are resources for EEOC, the California CRD, Legal Aid at Work. And again, we had mentioned in particular, Job Accommodation Network is fantastic. My colleague, Krista Watson, also with EEOC, has shared that Jan has a specific material aimed at medical providers. So please take a look at that. I know we're coming up on the end of the hour, and I have to say there are fantastic questions coming through both the chat and the Q&A. So if you can stay on, we'll try to answer one or two questions. And if not, thank you for joining us. And we will be sharing the links to the PowerPoint slideshow as well as the recording once it's available. So let's see. There's a lot of questions here. What's one that we should take a look at? I had a provider ask, oh, Zach, do you want to?
I was just going to say, there are a lot of questions in here that are like really specific hypotheticals. And while I don't want to just sort of like push those off to the side, I want to just emphasize that with ADA and with reasonable accommodations, there's so much information that we would need in order to actually be able to give an answer that would make sense to some of these hypotheticals. So I don't know that we could actually respond in a way that would be helpful when we're talking about, specific situations or specific accommodations for specific medical conditions, because again, it's all about a case-by-case analysis, right? Like when an employer's considering accommodating somebody, not only do they take into consideration, the specific limitations of the individual, but also the specific requirements of the job. And in a hypothetical, that's really hard to do and do that in a concise way. So I recognize the need for that kind of like advice, but it's not something we can really do in this sort of format. But our information is there. So if you do have a question or you just want to talk through, how these laws work, feel free to contact us. Feel free to reach out, and we will try to help you out. Try to help you understand what the law is. Jan again is another really good resource for suggestions on accommodations.
Since I see a lot of people signing out, I'm going to pivot and just say, Sharon, do you have any final words of advice or suggestions for folks?
Oh, I just want to say thank you to everyone for joining us and for engaging and asking your excellent questions. We are here as a resource. Please check out the template letters on Legal Aid at Work's website. And thank you for the work that you all do on behalf of your patients.
Definitely. Again, this is the first of our attempts to do this type of outreach. So if you have feedback, if you have a question burning that you want us to answer, please definitely reach out to any of us. We would be happy to engage with you, and we'd be happy to take tips on how to make this more effective for other medical providers to make sure that, everybody can collaborate for better health outcomes for patients/workers. Thank you so much, and make things better for employers as well. All right, with that, slides will be accessible, and I think if you registered and you're here, we'll figure out how to get you the links and the slideshow. So if you're in here, we will be sending it to you. Thank you so much. All right, with that, I think I'm going to close the webinar. Thank you all.
Thanks, everyone.
Thank you.
Rashida, I hope you feel better.